Good afternoon, everybody. My name is Paul Rudensky. I am the Senior Director for Education here at the Museum of Jewish Heritage, a living memorial to the Holocaust. I am pleased to welcome all of you to today's program, which is entitled Bitter Reckoning, Israel Tries Holocaust Survivors as Nazi Collaborators. I just wanted to say before we go further, I'm just going to ask everybody to mute themselves. We are being recorded, so if you could all do that, that would be much appreciated. Let me just say a few words about our topic and then a couple of announcements. Many Jews during the Holocaust, actually we can read it from here. Here we go. Many Jews during the Holocaust were faced with terrible dilemmas, which were essentially choiceless choices, whether it was to join the resistance but then put one's family at risk, or whether it was to flee to the forest, leaving others behind, or whether it was to not to share food with or another limited resources. Among the choices that Jews made were to cooperate with the Nazis and rule over, abuse, and sometimes murder fellow Jews. I myself recall hearing stories about how certain survivors in Brooklyn were shunned because of what they did during the war. How was the young state of Israel to deal with such people who had made Aliyah together with other survivors? In fact, the state of Israel prosecuted and jailed dozens of Holocaust survivors who had served as camp kapos or ghetto police under the Nazis. Today, Professor Dan Porat will bring light to many little-known trials held between the years 1950 and 1972 of survivors charged with Nazi collaboration. Scouring police investigation files and trial records, Professor Porat found accounts of Jewish policemen and camp functionaries who harassed, beat, robbed, and even murdered their brethren. Professor Porat shows how these trials changed Israel's understanding of the Holocaust and explores how the suppression of trial records, long classified by the state, affected history and memory. Sensitive to the devastating opinions confronting those who chose to collaborate, Professor Porat invites us to rethink our ideas of complicity and justice and to consider what it means to be a victim in extraordinary circumstances. His book, Bitter Reckoning, Israel Tries Holocaust Survivors as Nazi Collaborators, was a 2019 Jewish Book Award finalist. Let me now tell you a little bit more about Professor Porat. He is the Unterberg Chair in Jewish Social and Educational History at the Hebrew University of Jerusalem. He's the author of The Boy, A Holocaust Story. This work explores the famous photo of the boy with his hands raised as he and other Jews surrendered to the Germans during the destruction of the Warsaw Ghetto. It's a fascinating topic, but it is something for another time. Today, Professor Porat will be speaking about Bitter Reckoning, Israel Tries Holocaust Survivors as Nazi Collaborators. Our plan for today is as follows. Professor Porat will speak for approximately 40 to 45 minutes, after which time we will invite questions from the teachers attending the program and the gallery educators. Please feel free to use the chat function to submit questions, which will be read after Professor Porat concludes his remarks. We hope to end around or a few minutes after 2 o'clock. If people wish to stick around, we may have some time after that for a more informal discussion, but that's after we officially conclude the program. I want to bring your attention to the fact that I've sent a link to the first chapter of Professor Porat's book, which I invite all of you to read, and Professor Porat also invites you to read it. For those of you who are active teachers, I will be sending a link to an online evaluation form. Please plan to spend a few minutes completing it. Your feedback is important to us. Our next program, which is for teachers in Jewish schools, will be on Sunday, March 6th. It is entitled The Unusual Case of Fritz Scherwitz, the SS officer who rescued Jews. Author Anita Kugler explores the very unusual case of a German policeman and SS officer, Fritz Scherwitz, who managed to rescue and protect dozens and ultimately hundreds of Jews in Riga, including the artist Boris Lurie and his father Ilya Lurie. And now, without further ado, I am very pleased to hand our microphone over to our speaker, Professor Dan Porat.
Thanks, Paul, for the introduction, and good evening, good afternoon to all of you, good evening to me here in Jerusalem. Allow me just to share my presentation, and then we'll start. You all have it? Do you see it now? Excellent. Okay, so in the summer of 1952, a young 34-year-old woman, Sarah Zabitsky, a Holocaust survivor from Vilna, arrived at a hospital in the outskirts of Tel Aviv. She was 9 months pregnant, and she began to have contractions. She was admitted into the hospital, and as she was lying down on the bed, the midwife was called over to inspect her and see her situation. When the midwife, Luba Frankel, entered the room and looked at the patient on the bed in front of her, one could hear screaming come out of that room. On the one hand, the pregnant woman was screaming from pain from the contractions, and on the other hand, the midwife, Luba Frankel, was screaming at her, "You killed my family, you surrendered my family, you were a capo in the Warsaw ghetto, in the Vilna ghetto." This dramatic event, which was publicized in local newspapers at the time, was a very dramatic event, as I said, but it was only one of hundreds and hundreds of such encounters. Survivors arriving in the land of Israel, there were about 500,000 such survivors in the early 1950s, would encounter other Jews whom they found their family suddenly on the street. They found a neighbor from the town that they left, but they also found those Jews whom they viewed as the functionaries who had harassed them and who had surrendered them, either in the ghettos or in the camps. The generic term used at the time was the kapos. The capo being a Jewish policeman, the capo could be a Bulok Elteste in the camp. They all came under this general generic term. And the newspapers published several pieces on these encounters. One such piece is this titled from a newspaper, Charut, in the early 1950s, which reads 120 suspects of committing crimes against the Jewish people wander in Israel. The sense was that basically the reason that 6 million Jews had gone in the terms of the time as sheep to the slaughter, that they had surrendered without any resistance, was in many ways the responsibility of the Jewish leadership, the heads of the Judenrat, the Jewish police, the people in the camps, that basically misled the Jewish community and caused them to walk over and not resist the Nazis. In another title of a different newspaper in December of 1945, it describes a case where a Jew gets onto a bus in the center of Tel Aviv, line number 5, driving down Ben Yehuda Street, and he sits down in the bus and he looks across and he sees a familiar face, and he turns to that person and he says, "Are you Chaim Wilchatsky?" And the person does not respond. And then he repeats, "Are you Chaim Wilchatsky from Bendin?" And the person does not respond. He starts screaming in the bus, "This is Chaim Wilchatsky, the head of the Jewish Judenrat in Bendin. He is responsible for murdering hundreds of Jews." That person, together with the other passengers on the bus, they start screaming at this Chaim Wilchatsky, who runs off the bus, being pursued by the passengers and passerbys, and they all start to hit him. Luckily, the British police in Mandatory Palestine, there were a couple of policemen, took the person to the police station. Years later, he had to change his name to Chaim Aaroni, and he was killed in a car accident in 1948. Rumors say, and I don't know if they're correct or not, that car accident was not an accident, but was a mysterious death. And finally, probably the worst case that I am familiar with was the case that took place on January 6, 1948, when at midnight, a group of Etzel, the underground Etzel, headed by Menachem Begin, that underground movement, four of his people go to an apartment in the center of Ramat Gan, just out of Tel Aviv, and pull out a guy named Simcha Boinblatt, take him down at midnight, tie him to a bench in a public park, and four shots ring in that dark night. Simcha Boinblatt is killed, murdered for allegedly collaborating with the Nazis. And in the registry of the cemetery of Nachlat Yitzchak, where I went to search for documentation of this case, he is listed, as you can see here at the bottom, as Simcha Boinblatt, 24, Ashkenazi, shot, hospital, Ramat Gan, and this was January of 1948. In the other part of the registry, it documents that he was buried by the wall, as is common in Jewish tradition for betrayers or people who converted into Christianity, and number 88, and in parentheses, collaborator, ? He is buried to this very day without a gravestone in the cemetery of Nachlat Yitzchak. These very horrific, these very dramatic events of encounters between Jews and those whom they viewed as collaborators, those who they viewed as the people who caused their suffering, basically required attention from the authorities. And in 1950, a year and a half, or actually 2 years after the establishment of the state of Israel enacts a new law, the Nazis and Nazi Collaborators Punishment Law of 1950. This law, which some of you may be familiar, maybe know that Eichmann was tried based on this law, was actually enacted not with any thought of any Nazi coming to the land of Israel. Nobody imagined, nobody thought that any Nazi would think of making aliyah, and surely that any Nazi would be kidnapped and brought to Israel 11 years later. The law had two elements to it. It had the more symbolic element, the first part of the law, namely the Nazis. We, the Jewish people, the state of Israel, have the moral obligation and have the legal authority to try those Nazis. That will not probably happen, thought the legislators in 1950. But that was the symbolic meaning. The more practical meaning was the second half of the name of the law, the Nazi Collaborators. Those Nazi collaborators, in the view of the legislators, were Ukrainians, Slovaks, Dutch, French, but most and foremost, the Jewish collaborators. Pinchas was then the Minister of Education, of Justice, when he introduced this law before the Knesset, said, we have to first and foremost try our collaborators. And he cites a verse from the Bible saying, V'haya machanecha kadosh, your camp should be pure. We first have to cleanse our camp from collaborators, and that way we can require that the nations also try their own collaborators. And indeed, following this law, there were about 40 trials that took place, as Paul mentioned, between 1950 and 1972. Now, this law was a very unique law. It was unique in a few respects. It was unique in the sense that it was a retroactive law. It was legislated in 1950, where it applied to 1933 to 1945, and it was an exterritorial law in the sense that Israel never had jurisdiction over Europe. But despite that, it was legislated based on similar cases in the Nuremberg trial, and the formulation of the law was based on the Convention for Prevention and Punishment for Genocide. There were basically in the first paragraph of the law, which we will see now, there were basically three parts, three sub-paragraphs. One was crimes against the Jewish people. The second was crimes against humanity, and the third was war crimes. The latter two were based on the Convention for Prevention of Genocide. The first one, the crimes against the Jewish people, was a unique paragraph put into this law saying that the Holocaust was aimed and intended against specifically the Jewish people, and the law basically brings that in expression in its formulation. Now, the sentence for being convicted for one of these counts was very clear. The death sentence. Israel didn't stop the possibility of capital punishment in the 1950s, but in the case of Nazis, that the capital punishment exists to this very day. Now, following the legislation began the trials, the kapo trials. There were about 42 such trials against 40 individuals. In two cases of two individuals, they were tried twice. In one case, that person was twice exonerated, acquitted, and in one case, that person was twice convicted. There were about 350 investigations, and about 2/3 of the individuals who were tried in these trials were found guilty, and except for one, all of them were sentenced to jail time anywhere between 10 days to 6.5 years. Now, let me stress that some of these individuals were also tried in Europe before coming to the land of Israel. There was a whole system, which you might be familiar with, of honor courts in the TP camps and in the communities. And some of the individuals, also one of or two of those that we will discuss today, were placed on trial in Europe. And I discussed that in the first chapter that I sent you, those trials in Europe and how they transpired. Among those who stood trial were 35 men and 5 women, and 39 Jews and 1 non-Jew. The one non-Jew was a Slovak who was immigrated half mistakenly to the land of Israel. He basically was living in Czechoslovakia with his Jewish wife, and they wanted to immigrate to Canada. Their only way to exit Czechoslovakia, which was a communist country at that time, was to travel to Israel and then from here to continue to Canada. But when he arrived in Haifa in the late 1940s, early 1950s, he was identified by Slovak Jews who claimed that he was a collaborator, a member of the fascist Helenka Guard in Slovakia. And the stories that were told about him were horrific. There was a story about his killing of a 3-year-old boy on the border between Hungary and Slovakia, with very graphic details, which I won't go into right here and now. And was a case, he was accused of stopping a Jewish attorney on that border between Slovakia and Hungary, pulling out his golden teeth. But when the case came to the court in Haifa, the district court in Haifa, and the key witness gave his testimony, it became very clear that that witness was very, very much traumatized. He combined elements from the story from his experience in Slovakia with that from Auschwitz, and his whole stories didn't hold up. And the court acquits Andrej Baniak, that Slovak defendant, from all the counts against him. I should say that from a couple of years ago, I traveled to Prague and searched the Foreign Ministry archive in Prague, and it turns out that the court probably acquitted him on one of the counts mistakenly. He, in all likelihood, was a member of a fascist militia, the Helenka Guard, but the court acquitted him, and he left the country, moved to Canada, lived in Toronto, and wrote anti-Semitic and anti-Israeli articles there. So basically, the trials began as a means to channel the frustration, the anger within the Holocaust community, as I mentioned earlier, to channel it into a legitimate frame, being the courts. The courts were the way to basically avoid the lynching on the streets, to avoid the few cases of attempted murder, and basically the courts had to deal with this social unrest in the Jewish Holocaust community in Israel. The trials began in earnest in August of 1950, and I will now look with you at 3 of those trials, 2 of them from the early 1950s and 1 of them from the 1960s. Let me begin, oops, I went the wrong way, excuse me, with the trial of Dr. Pinchas Pshishtsky, which took place in 1951-1952. Dr. Pshishtsky, who was a physician, moves to Israel in November in 1950 and settles down in Tel Aviv with his wife and son. He finds a job in a local hospital and finds a nice apartment in the center of Tel Aviv. But 3 weeks later, he's identified and arrested on the count of serving as selecting Jews to death in the Wolno camp in the border between Ukraine and Poland. He's also accused of giving lethal injections to Jewish prisoners in that camp. In another word, he basically was a Jewish Mengele, a Nazi physician, at least in the view of the indictment. He is in jail for a year until his trial begins in 1951. And when his trial begins, the indictment right here, a 42-year-old physician, Attorney General of Israel versus Pinchas Pshishtsky, the first count is a count of the offense war crime, contrary to paragraph 183 of the Nazi and Nazis Collaborator Punishment Law. If you recall, when I presented the law, the Nazis and Nazi Collaborator Punishment Law, the option of war crimes or crimes against humanity, the sentence for that type of a crime was the death sentence. And actually in 15 of the indictments, the Israeli prosecution sought the death penalty for these defendants. Now, Pshishtsky is being accused of the details of the indictment, of the first indictment for war crimes, reads as follows. The details of the offense. The defendant, a physician in the Wolno camp in Poland, had done the following: persecution and murder of civilians in an occupied country when he murdered the following people at the Wolno camp: Rosa Rubenstein, Aaron Joseph Bauman, Shlomo Nugelman, Shalom Nugelman, Abraham and Baruch Nugelman, and he surrendered many of the camp inhabitants whose names remain unknown to a hostile regime. Basically, he is accused of murdering 6 people, 1 woman, and 5 men. The murder of the 5 men is based on the sole testimony of Rivka Nugelman, who is the widow of Shlomo Nugelman and the mother of Shalom, Abraham, and Baruch Nugelman, 18, 15, and 12-year-old respectively. Now again, she basically claims that Pshishtsky directed the Ukrainian collaborators, the guards of the camp, in 2 different instances to kill her family members. In one instance, to kill her husband, and in another instance, to pull out her children from the sick barrack and then shoot them. He has a personal vendetta against her and her family, as well as Aaron Yosef Bauman, who's some relative or friend of theirs. The court does not accept that. It is very clear in her testimony that she is looking for revenge, and the only way that she can get that revenge is by pointing and directing at Pinchas Pshishtsky. But the case of Rosa Rubenstein, the first one mentioned right here, is a much more complicated case. There are several witnesses who describe how Pshishytsky placed her name on the sick list, that he went to the barrack and pulled her out, that she screamed, I am healthy, I want to live. And he takes her despite that and pulls her together with 120 other individuals to a certain area where the Ukrainians and Germans shoot them dead. And Pshishytsky admits that indeed he put her on the sick list, that indeed he pulled her out of the barrack, that indeed she screamed, I want to live, I am healthy, that he ignored those screams and pulled her over to the Ukrainian place and she was shot. What is his defense? His defense is that that was the first time that such a selection took place, and he had no knowledge and he couldn't envision that the Germans or the Ukrainians will shoot these 120 people. The court accepts that defense and acquits Pshishytsky from all crimes and from the entire indictment. But the court at the same time has quite a critical view of Pshishytsky, as will be expressed in the last sentence of this excerpt from the verdict, and I will read it out loud. So the verdict reads as follows. This is the verdict of the District Court of Tel Aviv about the case of Pshishytsky. This is the place to point out two failed attempts, one by the defense and the other by the prosecution. The prosecution labored to convince us that the defendant oppressed the camp inhabitants on his own initiative as a kind of conscious, cruel, and bloodthirsty collaborator, while the defense labored to convince us that the defendant had a moral personality of an exalted physician who fulfilled his dangerous job for the benefit of the public. And we are convinced that neither is the defendant's character. And here comes a key sentence. We believe the defendant is a selfish, average person who hoped to better his situation and save his skin, and that without hesitation, he demanded payment from each and every patient he thought could pay. So the witnesses testify that Pshishytsky was called over to treat their relatives, and he refused to come unless, one witness says, he was paid 500 zlotys, when other physicians in the area, non-Jews, would charge at the time only 150 zloty. And he wouldn't come to see anyone or treat them unless he was paid money. Pshishytsky says, yes, I demanded money. I demanded money, but for a certain reason. I demanded money for the equipment. I demanded for disinfecting the syringe, for a broken syringe. The court does not accept that. The court says, basically, this is immoral behavior. This is very questionable behavior. We cannot criminally convict you, but you surely have, as the court says, you are a selfish, average person who was focused on your own interest and did not think about your community, your society at that time. So Pshishytsky is exonerated criminally, but there is a moral blot on him as a result of his actions there. Now let us turn to a second case. The second case is probably the most extreme case in these trials, the case of Yechezkel Jungster, who was in a camp, a Fulbrook and Groditze camp in Western Poland, and his trial was a trial that another person from that camp also faced trial, Jacob Koenigman. I will speak about both of them, but with a focus on Jungster, although both of them stood trial in Israel in the Tel Aviv District Court. This was a self-administrated camp. The Germans hardly entered the camp within the camp. They walked around on the fences, and the kapos, the Jewish kapos, basically managed the camp. There was some of self-administration within the camp. Now, the indictment of Jungstill included 7 counts of crimes against humanity. We remember that crimes against humanity, the law demands the death sentence. But there were also other indictments for, so to say, ordinary harassment of fellow Jewish inmates. And here is a typical testimony of one witness of the way that Jungstill treated Jewish inmates in the camp. He says as follows: if a person did not jump from his bed with the required speed, he struck him with his stick. If he found a bed not made exactly as it should be, he would hit him with his stick. If he found a pair of shoes not lined up precisely, he would strike. So this type of testimony, and there were several such testimonies, of the way he basically hit people in their genitalia and their private places, and he was harassing them within the borders of the camp. He avoided doing so outside the camp where the Germans were present because he feared their response. Jungstill tries to bring defense witnesses in his favor to counter the 15 prosecution witnesses, and he hardly is able to find any witnesses in his favor. One of the witnesses he's able to find, and it's important to mention this, is another capo who is considered by the inmates as a good capo. And we should remember that the majority of the capos, whether they were in the functionaries and the camps and the ghettos, were good, but there were some exceptions. So this good capo comes to testify in the defense of Jungstill, and he admits that he himself had hit Jews, and he admits that he himself mistreated Jews, but always, only when Germans were in present. When Germans were not there, he only, as he said, his voice roared, and people acted based on his screaming loudly. So even this defense witness, this good capo, Zvi Schlimmer, tells the court that he saw Jungstill hit in ways that were not necessary and times that were not necessary. So the court finds Jungstill guilty of harassing Jews in several cases. And for that, he is sentenced to 2 years in prison, served concurrently for several such cases of mistreating Jews and harassing Jews. 2 years in prison. But here comes the more complicated, another element of the trial. Remember that he was also indicted for crimes against humanity, and the three judge panel, 2 of the judges come to a conclusion that there are elements in these harassments that brought together, all these harassments come together to the case of crimes against humanity. The court explains, these 2 judges, the majority on the panel, explain why they believe that Jungstill should be convicted for crimes against humanity. And they say that the crime of crimes against humanity has 2 elements. The first, and I'm citing, the action has to be of a severe nature that might make a person miserable, humiliate him, and inflict on him grave physical or mental torments. That, they say, in these beatings in private places, in the beating altogether, that standard he qualifies for. And the second, the action must be committed against civilians in wide scale and in a systematic manner, and in a way that arouses a revolt of conscience and human emotion. And they say there are enough cases that we can say that this has been done on a wide scale in a systematic manner and in a way that causes revulsion in human emotion. And here comes the sentencing of this Jungstil case. The court reads, sorry, I went the wrong way. The court, the majority reads, states in its sentencing, we approach the sentencing in this case with dread. The law does not leave in our hands any choice but to sentence the defendant to death. It is quite clear that it is not the same to order the death penalty in the case of a Nazi criminal who identified as a Nazi or identified with a barbaric Nazi regime, and in the case of this defendant, who himself was a persecuted person and lived in inhumane conditions like his victims. But say the majority on the panel, we have no choice but to sentence Jungstil to death. Within a few weeks, the death sentence in Israel in the district court automatically creates an appeal to the Supreme Court. It must be appealed. And indeed, the Supreme Court, on the same day that the case comes in front of it, it decides to vacate the conviction for crimes against humanity, and Jungstil basically is sentenced to 2 years in prison for harassing Jews in the camps. He goes into jail. Within a few months, he becomes very ill. His right leg is amputated, his kidney is removed, and within weeks, he is allowed to leave for health reasons the prison, and within 2 weeks of his release, in July of 1952, he dies a natural death in his home. But this case of a death penalty issued against a Jewish capo creates an outcry and an understanding in the Israeli prosecution in the Attorney General's office that cannot happen again. And there were 15 such attempts there were 15 indictments of Jews that included either war crimes or crimes against humanity, and the prosecution quickly rushes to change the indictments so there will not be any repeat case of a Jew being sentenced to death for his actions in Europe. This is the first time, the first distinction. If up until now the law applied equally to a Eichmann and a Jungstil, to a Nazi and a Jew, from here on, there is a distinction in the interpretation of the law, basically saying that the first paragraph of crimes against the Jewish people, war crimes and crimes against humanity, does not apply any longer towards Jews. It applies only towards Nazis. And here we come to the final case, which I want to present to you today. I should say that in between was the Kastner trial, which I must emphasize is not one of the Capo trials. It is a libel trial. It was shaped by the Capo trials. It shaped the Capo trials, but it was not one of them. It's not a criminal law-based trial based on the Nazi and Nazi collaborators law. So here we come to what is in practice the last trial of the Capo trials. There was one still in 1972. If you wish, I can talk about it later in the Q&A. But this case is the case of Hirsch Barnblatt. Hirsch Barnblatt was the head of the Jewish police in Bendin, and he moves to Israel. He's a musician by profession, and he moves to Israel in the late 1950s, and shortly thereafter gets a position as the assistant or the deputy conductor of the Israeli Opera House. Within a few months, he's identified by survivors from Bendin, and the police arrest him and take him into investigation. This is in 1961, at the same time that the Eichmann trial is taking place in Jerusalem. The prosecution decides not to place him on trial at the same time that the Eichmann trial is taking place, and his trial begins in 1963. He is the indictment includes some very horrific counts. In one count, he is accused of surrendering anywhere between 5,000 to 10,000 Jews into the hands of the Nazis. In another count on the indictment, he is accused of pulling out from the attic of the local Jewish orphanage anywhere between 70 to 100 orphaned children, handing over to the Nazis without the Nazis even knowing of the presence of the children there. But the unique indictment, the unique count in the indictment is actually the 12th count on the indictment, and that is this one. Let me read it and we will see what's unique about it. The 12th count reads as follows. The above-mentioned defendant, Hirsch Bauernblatt, in the time of the Nazi rule, was appointed to serve as commander of the Jewish police in Bendin, a position in an enemy organization, which he fulfilled until October 1943 in the service of the Jewish Council and the Nazi authorities, one of whose aims was to assist in carrying out actions of an enemy administration against persecuted people. This count, based on paragraph 3 of the law, was only once before used in an indictment in the Israeli kapos trials, and that in Israel altogether, and that was in the Eichmann trial. What is so unique about this count? What is so unique about this count is that the prosecutors designate the Judenrat and the Jewish police as enemy organization, whose aim was to assist in carrying out actions of an enemy administration. They basically equate between the Jewish police and the Judenrat to the SS and the Gestapo. And the testimonies in the trial indeed follow this. Here is a witness talking about the actions of the Jewish police. The Jewish police, says this witness, received their orders from the chairman of the Jewish Council, and the chairman of the Jewish Council received his orders from the Gestapo. As a result, they, the Jewish police, did all that the Germans wanted and did it in the best possible way. You can clearly hear here the echo of Hannah Arendt, who accused the Judenrat for helping the Nazis kill 6 million. She says that without the Judenrat, the Nazis wouldn't have been able to kill so many Jews. The case goes to the, as I said, was heard by the district court, and the district court finds him guilty on different counts, but this 12th count was pulled away from the indictment before the verdict. There was political pressure to remove it because there was fear that if he would be found guilty for being a member in the Judenrat only, without any action, without any thought about intention, there would be thousands, hundreds, if not thousands, of functionaries in Israel that would need to stand trial. And the Israeli system could not stand up to that. So that count is removed, but the district court says, had that count been on the indictment to the very end of the trial, we would have convicted Bauernblatt of membership in an enemy organization. The case goes up to the Supreme Court, and the Supreme Court basically marks the target that we must put an end to these trials. And it makes a point of criticizing the prosecution for placing that offense on the membership in enemy organization, that 12th count, for placing it in the indictment. The president of the Supreme Court, Yitzhak Olshan, says, even the most extreme critics have not charged that the Judenrat and the Jewish police aimed to assist the Nazis in the extermination of the Jews. And in his verdict, another justice in this case, Moshe Landau, who also sat on the panel that convicted Adolf Eichmann, gives the overall view that these trials must come to an end. And he writes as follows: "It would be hypocritical and arrogant on our part, on the part of those who never stood in their place, to criticize those little men who did not rise to the heights of moral supremacy when mercilessly oppressed by a regime whose first aim was to remove the human image from their faces. And we are not permitted to interpret the elements of the special offenses defined in the Nazis and Nazi collaborators law by some standard of moral conduct that only few are capable of attaining. One cannot impute to the legislator an intention to demand a level of conduct that the community cannot sustain." And with that, the Supreme Court puts an end to these trials, with one exception in 1972. Let me end, and in conclusion, cite the very famous Primo Levi in his essay, The Gray Zone. Primo Levi writes as follows: "The condition of the offended does not exclude culpability, which is often objectively seriously. But I know of no human tribunal to which one could delegate the judgment." Levi, on the one hand, says, right, that that the offended, being a victim, does not exonerate a person. You could be offended, does not exclude culpability, which is often objectively serious. There were indeed victims who acted in inhumane ways. But at the same time, it says, I know of no human tribunal to which one can delegate the judgment. We have no way to try them in a court. He says also that these people are rightful owners of a quota of guilt. Basically, there's some tension here within the words of Levi. On the one hand, he says we cannot try them, and the other hand, he says they're rightful owners of a quota of guilt, and the offended does not exclude culpability. What I believe he means to say is that we cannot put these people in trial, but we have an obligation to discuss their cases, to understand their moral behavior or immoral behavior without coming to a judgment in court. But if we want to learn from the actions of these individuals, which will help us become ourselves better humans, we must discuss the cases of these individuals, such as those that I presented in the Kapo trials, who on the one hand were victims, but at the same time acted in immoral ways, or in questionable ways, should I say. Thank you very much for your attention, and I will now stop the sharing and turn to the, let me turn it off, and I'll pass it over to Paul.
Thank you so much, Professor Porat. That was a fascinating presentation, and really, I think opened the new perspective in terms of understanding what it was like to be, the context of Israel right after the war, the first few years of the state of Israel, but also when all of these survivors were there, including these people who were accused of collaborators. I'd like to now invite the participants to submit questions in the chat. When we finish the program officially, we'll have some time also to schmooze a little bit more informally, but for now, I would like to ask people to submit questions to the chat. And I wanted to pose a question, if I may. So I guess I'm a little bit confused. So these people who were accused of some of these terrible crimes, what do you think? Do you think that they did them, or do you think that it's really that these people were so traumatized, that the survivors who saw them were so traumatized that they had to, accuse somebody? What is your, I know you weren't there, but what's your feeling?
Look, there's no doubt that there were cases of people who did horrific things. I did not mention this about Jungster, but there was an account of Jungster and Koenigman pulling a group of Jews, forcing them. These are new arrivals at the camp. They force them into a washroom, and they send all the inmates to the barracks. And the inmates in the barracks testify that they hear screaming coming from the washroom. That basically Jungster and Koenigman beat anywhere between 8 to 12 Jews to death. Now, the court could not convict them and could not convict them for murder. In no case was a Jew convicted in Israel for murder of other Jews. But there's no doubt that that case happened. There's so many testimonies, and there were no Germans in the area. Or in all likelihood, there were no Germans in the area. And the court cannot convict them because there is no death certificate, there are no names, there are no direct testimonies. There were victims who behaved in horrific ways. They were victims, and at the same time, they acted in horribly, in terrible ways, in very questionable ways. Now, the case that I just mentioned by Koenigman and Jungster is an extreme case, but there were also cases, just take that case of Pszczycki, taking money for medical services and taking exuberant amounts of money. He acted in very questionable ways. Now, if you are asking whether there was a place to put them on trial, so Primo Levi says no. I believe that at least in the first years of the 1950s in Israel, there was no other choice. One had to find a way to channel the vigilante justice, the violence into the courtroom. After the Castile trial, it was already a time to stop those trials, but I said that basically the trials had to end earlier than, I believe they were justified in the 1950s, early 1950s, but at a certain point, they continued for too long after the Castile trial.
Right, thank you so much. Now we do have some questions that have come, and that's fascinating. Thank you for that answer. We do have some questions that have come in, so let me. And
by the way, if people think differently than me, they're invited to express different opinions. I'm completely open for that, whatever you want.
Okay, thank you. In the chat.
Sure.
So far in the chat. Okay. So let me take a look at some of these. Okay, here we go. Okay. Okay, so here's a question from one of our teachers. Can you describe the process of how somebody became a capo? And did these people volunteer, or did the Nazis send something about them before they appointed them for their positions? And then that's question number one. There's a couple questions here, but that's question number one.
Okay, so there are different instances in different locations. Let me say that many victims wanted to become functionaries, and understandably so. No doubt that if I were in that situation, I would have wanted to become a capo. Why so? Because being a capo gave you better working conditions, gave you better food, gave you, in the case of Jewish policemen, if you became a Jewish policeman for a time, you were able to protect your family. You could get food for your family. But there were, among those, a few. We should remember that being a capo is a bad word in today's world, but most capos were not bad people. Most of them behaved okay, we should say. But there were those who took the power in their hands and used it in questionable ways. They were a minority. They were a small group of the victims, of course, in large, and also a small number of those capos. But we have to discuss their cases because it shows what happens to a society under stress. In a horrific situation, a society breaks up and there are individuals within it who behave in questionable ways. So in each case, getting that position was in a different way. There is one account in one of the trials of a woman, Raya Hannes, who was a capo in Auschwitz, where she is described how the Nazis place her between the electrified fences for 2 days in a row so as to force her to become a capo. And she becomes a capo. and she's put on trial in Israel. And the testimonies are horrific against her. But the judge, in fact, and there are also many testimonies in her favor, but the judge, in fact, says that she was a hero. This kapo was a hero. Why so? Because she behaved in what seemed to the inmates in a horrific way, so as to be able, behind the scenes, to assist them and help them. If she would have behaved nicely towards them, the Nazis would have removed her. So it's a very complex question about how to judge these people. There were among them who were heroes, and there were among them who behaved in very questionable ways.
Thank you for that answer. The other question is, and I think other people have asked this as well, was, can you just mention something about the trial that was held in 1972, since that seems to be so many years after the Supreme Court essentially said enough of this?
Yes. So when the Supreme Court said enough of this, it gave one caveat, and that one caveat was in cases of extreme cruelty or sadism, you say?
Sadism.
Sadism. And in 1972, arrives in Israel a tourist from West Germany, Luba Gritzmacher, and she is identified on the street in one of the suburbs of Tel Aviv. Now, not only was she living in Germany, West Germany at the time, but her husband was a very notorious kapo. And some of the people whom he oversaw became influential individuals in Israel. Among them, a district court judge, if I remember correctly, also the chairman of the Knesset, Dov Shilansky, was one of his inmates. And they decide to use the opportunity. They don't have the opportunity to put Gritzmacher, the husband, on trial. They will try his wife, who was also a kapo. And they find testimonies of women whom she oversaw, whose fingers she broke because they used the soap of Nazis. And she's put on trial in Israel and convicted and sentenced to 3 months in a jail. I should say it's interesting that a few of these kapos, at least 3 in my memory right now, maybe more than that, after the trials, where do they go? They move to Germany. When we talk about Ballenblatt, he moves to Germany. Why Germany? Because in Germany, nobody will put him on trial or harass him. Gritzmacher is another example, and there are a couple of other examples of kapos who moved to Germany so as to defend them or to avoid prosecution or to live their life there.
Thank you for that fascinating insight, or fascinating fact. A couple more questions, then we'll probably bring it to a close, at least our formal part of our program. Could you speak a bit about the motivations of those accused of these acts? Like why were they doing what they were doing? Is that possible?
Well, here I'm going into psychology, which is not my field, but I'll give my one sense of understanding of what the reason. At least in some cases, they became what's the word? They just felt the ability to use power and use it in horrific ways. Not Ballenblatt. Ballenblatt was terrified. He was terrified. He even sent his wife to death and to Auschwitz onto the trains. He was just a person who couldn't suffer even a little bit. And he joins, it's interesting that there are few cases of Jewish policemen who know what the future is when you are sent on those trains. And they go into the rebel movement. So he joins the rebel movement after he surrendered orphan children and thousands of other Jews. But I will say that there were different types of motivation. There was the fear, there was love of power, there was wanting to assist your family and get better conditions. But that was for the entire couples. There's nothing wrong about that. any inmate would have taken that position had they had the opportunity to do so.
All right, thank you. And I think we can probably squeeze in one more question, and then since it's already past 2 o'clock, we'll bring the formal part of the program to the close. But could you speak more about the Supreme Court's changing the punishment for Jewish collaborators?
Sure. So that's the case of Ballenblatt. I mean, there were a few cases that came to the Supreme Court. The Supreme Court, up until the case of Ballenblatt, never overturned a case. Never. It reduced the sentences. It did. Okay, there were sentences that were reduced by a third, by a half, but it never turned over. Now, when the Supreme Court faces the Ballenblatt case, this is after the Eichmann trial. The Eichmann trial, basically, in the Eichmann trial, Israel, including the Supreme Court, finally found the true culprit, the true evil, the Nazi German. It was not the Jews or the leaders of the Jewish community who were responsible any longer. It was the Nazi. And it was an understanding that by trying those small Jews, we are not dealing with a true culprit. When Ballenblatt comes up to the Supreme Court, in my view, in my interpretation of the verdict, first marks the target and then draws the arrows. It first marks the target. We must exonerate this individual. And it finds virtuosive ways to basically find anything that was any negative testimony to vacate it. And in this example, in the case of the orphanage of the children being pulled out from there was one adult witness and one child witness who witnessed this. And the court says they are probably imagining it. It's impossible, says the court, that Jews surrendered Jewish children to the Nazis. Well, we know from history in the Warsaw Ghetto that happened several times, that the Jewish police surrendered Jewish children. That was the norm in this upside moral world. But the Supreme Court wants to exonerate Ballenblatt in any possible way, and basically vacates all the, or doesn't trust any of the witnesses there, but not in ways that are politically don't offend them. Basically says they probably mistaken, they probably are taking it from a different story. But I have no doubt that had this trial been brought before the Supreme Court and the District Court in the early 1950s, Ballenblatt would have been convicted and sent to jail, and his trial, he would not be exonerated as he was in the 1960s. It was only because it came after the Eichmann trial that the Supreme Court decides to put an end to these trials and exonerates him and uses that as a tool to stop the entire couple trials.
Thank you so much for that explanation. And thank you so much for a fantastic presentation. I learned a lot, and I think everybody who was here did as well. So I'm going to stop the recording now. If anybody would like to stay on for a few minutes and speak with Professor Porat, I'm gonna allow you to do that. We are going to do that. So I'm stopping the recording. Okay.